sold property like that without the input of the other person, okay? And then other people say, but why are you sitting down for him to do that to you? And it's like, I'm a wife. What can I say? If I say anything about the property, they'll say I'm greedy.
If properties are acquired in the course of the marriage, there's a presumption. It is presumed that it's supposed to be owned by the two, unless there is it is expressly stated that no, it's for only one person.
Right.
If you're going to dispose of your interest or encumber it in any way, then there's a need to get the written consent of the other spouse.
If I look at the advancement of the law, I'll say, let it slide. Let them go on. The judges are making law, and we waited for this for over how many years? So let them, and they're doing quite well. We
help to craft some special provisions for polygamous marriages where there will be equity amongst the women. So there'll be equity between them, among themselves, and with the man.
When I went to market and I bought tomatoes, my husband was building. He used his money, and I used my money for tomatoes. So please, tomato seller, give me receipts. No woman has those receipts, and yet they contribute tremendously from morning first to wake up, last to go to sleep.
There are also men who are now going to court. I handled a case where there was a man who was making a claim for properties that the woman was in the woman's name, saying that he had an interest.
If we don't set it in context, people think, oh, the women, they are greedy for money. They desire to take over their husband's properties. I'm telling you, all of our husbands think like that, one way or the other. But it is a spouse's, not just the woman's, property rights, and this is emanating out of a situation of injustice and a lot of cruelty sometimes.
Provision as a spouse's bill, which we've not spoken about, is it gives the parties the right to come up with what they call marital property agreements. So at the onset of the marriage, the parties themselves can sign, hey, this is my property, this is yours. It's when we're going to acquire, when any property is being acquired in the course of the marriage, unless you contribute, all those things can be put in there.
Good afternoon and welcome to yet another edition of The Law. This is your legal light and health law. And this afternoon we are continuing from last week. And as you remember, last week we treated the topic, property rights, spousal property rights. Have the keys been handed to women? And we're doing a part 2, which will spend a lot of time on question and answer session, because we discovered last week that by the time your questions began to come in, we had run out of time. So today, as we continue the conversation on property rights for women, a caller brought an interesting problem last week. According to Gladys, who called into the show, her husband of several years has married another woman, and not only that, she alleges that she has been forced out of the home and moved into the boys' quarters, and the man has given out the house for rent. We will get you to listen to that shortly, but let me introduce my guests to you, and then we will get some solutions. So just get ready. We will spend a lot of time today to answer your questions in respect of this new law and what it seeks to introduce. I'm Samson Ladi Anyenini. My guests this afternoon are my very good friends, Alexander Etua Into, who is Senior Legal Officer, Lands Commission, Koforidua, and Mrs. Veronica Frimpong. She's not new to this platform. She's former legal officer, Lands Commission, so two friends coming together, Lands Commission, and head of legal at the SIC Life Savings and Loans. Ladies and gentlemen, thank you so very much for making the time to join us on The Law.
Thank you.
Great.
Thank you, Samson. Good afternoon.
Good afternoon. Thank you all so very much. Now, I'd like us to begin from where we ended last week. I'd like to pick our two guests, their views on this same law. They are men who are very uncomfortable with this law. And this new law simply is that property that is acquired within the marriage, during the marriage, is presumed to belong to both husband and wife. It doesn't matter who acquired it. Unless a contrary, statement has been made, as in the process of acquisition documents, that property will be presumed to belong to the couple. And on that note, no one partner can sell the property, mortgage the property, give the property out as a gift, or lease it out, whatever, can deal with it without the other partner giving their consent and doing so in writing. Let's start with Mrs. Veronica Frimpong. Share with us how you would like our viewers and listeners to appreciate this law, and whether you think it's a good law, particularly in favor of spousal property rights for women.
Okay, Samson. I'll start by explaining what the provision is, things we should look out for in the provision. Then I will give my views as to whether it comprehensively addresses spousal rights. Section 39 raises that presumption you were talking about.
Right.
When you look at the provision 39.2, if you may permit me to read.
Please go ahead. Please go ahead. I think you are muted.
Hello?
Yes, go ahead. We can hear you now. Yes.
38.3. In a conveyance for valuable consideration of an interest in land that is jointly acquired during the marriage, the spouses shall be deemed to be parties to the conveyance unless a contrary intention is expressed in the conveyance. It says four things. First of all, the property must be jointly acquired during the marriage. Second thing, there should be valuable consideration for the acquisition, so that if it was a gift to one of the spouses, there was no valuable consideration in the acquisition. So you don't expect that if your partner got a gift of a property, then you are automatically a joint owner. Then during marriage, we have other laws that define marriage or show us the kinds of marriages that are recognized under our laws in Ghana. We have the ordinance marriage, we have the customary marriage, and then we have the Mohammedan marriage. And so you must be married. If you are not married, you can't come under this provision. For the joint acquisition, we know that once there is marriage and the property is acquired, because of that presumption that because it's acquired during the marriage, there's a presumption that it's a joint acquisition. And that's also the fourth one. But let's note that when you come to 38.4, that presumption could be rebutted. And is the lawyer preparing the conveyance? So the lawyer can put in words that indicate that it's only one of the spouses who is acquiring the property. It doesn't shut the other spouse out completely. If he or she thinks that she is supposed to be a joint owner, you can challenge in court. But just on the face of it, you have to know that the other person can prepare the conveyance or can get the lawyer to prepare the conveyance such that it seems to take you out of the joint ownership. So those are the four things. As to whether the provisions are good, I think it's a good provision, but I don't think it's comprehensive enough. Right.
Now, what you have just said to conclude means that those who are worried are unnecessarily worried, particularly the men we have heard express so much worry about the law that it will take away their property, which was meant for them personally and individually from them, and give them to or part of it to their spouses, their wives, in the manner that they didn't intend. And of course, we know that there are some women who also have a similar concern. You're saying that there is no automaticity, so to speak, in the joint ownership, even though the property may have been acquired during the marriage, right?
It is automatic to the extent that you don't indicate that you are acquiring it alone as an individual spouse. Then it becomes automatic. But I'm saying that there's a way out.
Okay.
So then people should not be unnecessarily worried, because if indeed you acquired it alone and the understanding between you and your spouse is that this property is supposed to be your sole property, then you shouldn't have a problem. And as you mentioned, something, maybe the women may appear to be happy because in the majority we see that the women are more vulnerable.
That's right.
But some women are also not happy with the provision. I was lucky to be part of the consultation at the point in time, and I noticed that some also raised that issue. It should be a few of them though, but it cuts both ways.
All right. Thank you very much. And as you spoke, you kept saying it depends on the how the conveyance is done, how the lawyer will draft the conveyance. Help us understand, even though we have put the meaning of conveyance on our screen for our viewers. What do you mean when you say the conveyance? What is that?
A conveyance is simply any document that transfers or indicates ownership in land. So it could be a lease, it could be a sublease, it could be a freehold conveyance. Any document that is evidencing the transfer or giving an interest to the party or somebody, it's a conveyance.
Thank you very much. And our viewers will remember that you took your time patiently to explain these things to us not too long ago. Yes, Ms. Nto, what's your view or interpretation of this law, and how good is it, particularly for the fight for women's property rights in this country?
Samson, and I must greet the listeners. Samson, I will start with saying that these particular provisions are good for the entire society. Society is made up of families. You see, previously it was left to the discretion of a single judge or a number of them. Now, once it's codified, it gives every woman and other partners, not only women. Here we are talking about property rights of spouses. So it gives them the confidence and reliability that there is something expressly stated that can be used for their benefit. Something, the law as it is, it has the 38 provisions that my sister just quoted. One, there is a provision that goes to say that it is deemed that when you prepare a conveyance and it comes in one spouse's name, the other spouse's name is automatically part of it. And then it goes on to say that where you leave it out, it means somebody may interpret it to say that it is once the thing is left out, it means he did not intend to include it. So the exclusion clause, exclusion interpretation or expression is given to this particular provision. But here the law says that when it's left out, it is presumed, which is a rebuttable presumption, because the couple can make an agreement to say that for this particular property, which was acquired during the marriage, this is how we want to manage it. This is your portion. Or you are not part of this, so you cannot participate in the transaction if it comes to transfer or any other form. That has to be done with the property. But you see, the Constitution is the bedrock of all these laws. Article 22 has made it clear that a spouse has equal access to that joint acquired property during the marriage. So, with this law, it goes to emphasize and expand the scope to show that it is no longer a matter of saying that You just have an access, you can use it. But when it comes to the proceeds or benefit from it, you have nothing. When it comes to dissolution of the marriage, you have nothing. No. The law has made it such a way that now, beyond access, you can also say that in spite of the fact that you did not make financial monetary contribution or contributed cash, your services in kind can also be used to benefit your interests. And it goes both ways, because a man may assist the wife and a wife may also assist the husband. So when you create an environment for your partner to be able to acquire this property during the marriage, I think it is fair. And the law, though the property rights bill is pending, others may say that this is not comprehensive enough. I may agree to some extent, because this law is meant to deal with land issues. All the various scattered land statutes in the country is now put together, is consolidated, and other relevant elements has also been added to make it easier for us to use. But when the property bill, property rights bill is passed, maybe it will make it more comprehensive than it is now, because this one is specific. You can exclude your partner if you agree to do so with your partner. Samson, that is my view on this.
Thank you very much. Now, to any one of you, how do we bring in the section 97, particularly 97.4 of this new law that is gaining so much attention, particularly this provision that the two of you have so eloquently explained? How do we bring in the section 97.4? Section 97.4 says an application for registration of land or an interest in land jointly acquired for valuable consideration during marriage shall state the spouses in the marriage as the applicants unless a contrary intention is expressed in the conveyance. How significant is this to the explanations that you have given? Maybe start with you, Mrs. Frimpong.
Something, when you want to register a land, especially title registration, there are forms you fill. You provide some of the details in the conveyance on that form. Now, this provision to me is very important because you may have left out the name of your spouse in the conveyance itself, but you may not have indicated that the property is solely acquired by you because both of you agreed that way. And so on the form, once it is not acquired solely by you, you have to indicate that the property is for the applicants are yourself and then your spouse as well. And I think it also gives the registrar the power to probe and probably ask for some further proof to show that you are indeed the sole owner, so that if there's no indication on the conveyance and then maybe some evidence in addition that the parties agreed or that you acquire the property solely, then the registrar can put some questions and probably refuse to register it for one spouse. Or even if he proceeds to register, still there's the presumption that you hold it as a trustee.
They say laws are made. Well. They say laws are made sometimes to fill a lacuna or to cure a mischief. What does this seek to do?
Something, most of the times people acquire properties jointly and you realize that it's one spouse's name on it, mostly the man. Sometimes you ask and then they'll tell you, oh, my wife witnessed it, as if signing as a witness makes you a part owner or a joint owner in a property. So it's just to ensure that maybe on the face of the certificate or the entry in the register, even though the presumption is there, if there is opportunity for the other person's name to be added, so that clearly anybody probably conducting a search can know that this property, or when you intend to deal with it, is easier for the prospective buyer or grantee to know that it is jointly held or jointly owned.
Right. Mr. Nto, what do you say?
So, the section 97(4) says that, it says to the effect that this property acquired during the marriage shall state, on the conveyance, shall state the spouses in the marriage. The word is, I want to emphasize on the word shall, which is mandatory. So to the land administrator or the registrar, he must ensure that henceforth, if a man presents a document and it's in his name alone, he can demand that that first page should be amended to include his wife, because that is what the law is seeking to do. If he has any contrary view, then that must be expressed in accordance with this act.
So there's clearly a mischief that this law, this provision cures, and it cures it more particularly in favor of men or women in a marriage. Tell me, Into.
It cures it in favor most. This one, you see, the law is gender neutral. So as a lawyer, I would say it cures it for both sides. But you see, our society has been skewed such a way that women have been at disadvantage for too long. So it comes to cure the mischief in favor of women. You see, because we can't do without women. They are part of us, and we achieve what we have with them, unless you are single. You see, so it actually helps to bring in the interest of these women who have contributed in a way which society don't see or recognize as paid job.
Right. The way Veronica was nodding, you want to say something in addition to that? More particularly, you see, upon death, the problems that come up. This is very useful, right?
Yes, something it is. And I would even say that, if you look at how the courts or the judiciary have tried to make some inroads as far as Article 22 is concerned, you realize that mostly the sympathy or the empathy is upon dissolution of marriage or upon death. But I say that when it comes to the access, which is Article 22(3)(a), there's a problem. Because in marriage, most of the time, the weaker spouse, and mostly women, do not have a say. So that the property is registered in your husband's name. He chooses to sell the property. He chooses to rent it out. He takes the proceeds, may decide, if it's a customary marriage, may decide to go and take a second wife out of the proceeds that they get, may decide to use that money to probably acquire property for his family, and you may not have a benefit. So I think that this provision particularly is very important because on the face of the document, the other spouse's name is shown.
Thank you so very much for this very extensive explanation of this law. And for those of you who are joining us for the first time, if you didn't join us last week, we are looking at the new law in Ghana. It's known as the Land Act 2020. Land Act 2020. Act 1036, which has become law now in Ghana, and it is the law that regulates how we deal with property, and if you like, more particularly landed property. It was assented to by the President on the 23rd of December 2020 and gazetted on the same day. Now, like they say, ignorance of the law is no excuse. From that date, the 23rd of December 2020, this law is in force. If there is property made within the marriage, and you would recognize that Mrs. Veronica Frimpong took time to emphasize that it must be within the marriage. And then she spoke about 3 forms of marriage recognized in Ghana by law. Customary marriage, which is potentially polygamous, and then marriage by ordinance, which you may say is Christian marriage, so to speak, and then you have the Mohammedan marriage, which is the Islamic one. So if your marriage, so to speak, doesn't fall within these recognized, ambits of the law, you cannot be making this claim for yourself. Right. Now, we are going to take your questions and then they will expand further on it. Last week, we discovered that by the time the show was ending, there were just too many of you who wanted to ask questions and we couldn't do that. So let's play Gladys's question. She had called in and asked a question, but we couldn't answer it. Let's play what she had to say and start with that. Meanwhile, you can begin to call or join us with your questions.
Yeah, and I have some problem to discuss with you people. I married and I stay with a man almost 20 years. And he go and marry another woman. Now we stay at a house. Now the man put me in this boys' quarters and hire the self-contained. Meanwhile, I stay with him some years. We have 4 children. And now I'm in this place, boys' quarters, and we have a self-contained now. I need your help.
All right, so we took Gladys's question and feel that even though it may not have appeared to be directly concerned with the subject matter, we discovered that what she may have been concerned about will be about the fact that she's been moved into the boys' quarters. She's been with this man for 20 years, they have children, and she didn't give us any more explanations apart from what she has. Either of you, what can we say to Gladys? Yes, Into, let's go.
You see, the Constitution and Article 22 says that to the effect that the other spouse must have equal access. So whether it's a self-contained or whatever is attached to it, you see, the woman, the question she asked seems to me that she's being relegated to a lower status by putting her in the boys' quarters.
Yeah, the man has already taken another wife.
Another wife. Okay, so they are in the main building, which is the self-contained. She has equal access, just like the other wife. If it is customary marriage, she must have equal access. So this is something she can apply to the what do we call it? The juvenile tribunal, where they deal with these family issues or social welfare for this matter to be resolved. It is not everything. I wouldn't recommend that she goes to the court.
Okay.
Because it's not every marital issue that should go to court. What I mean is the superior court.
Right.
But the lower court, social welfare, can deal with this matter, call the parties together and resolve it. Or he can even start from the community level.
Okay.
To have some kind of DR to resolve it.
All right.
Because
Yusuf and Robert, I know you are on the line. I'm going to come to you shortly. But Sister Report, do you have anything to add to what Into had just said to Gladys?
Yes, obviously. She says they are married, and I would want to think that it's formal marriage of a sort.
Right.
Once the man has gone for another wife, probably it was a customary marriage. 20 years is a lot of time, and if the property was acquired during the marriage, then obviously she would have contributed for 20 good years. The contribution is part. brings us back to the access point that I was making earlier.
Exactly.
See, if the marriage was dissolved, it would have been easier for her to, you know, sometimes go to court. But sometimes you don't want to shake the already muddied waters too much, and so you'd want to keep quiet. But this is joint property. They hold this as tenants in common. For now, it's undivided portions. If the man thinks he can go, he's gone for another wife, then they may decide to split the property, and then the man may share his portion with his new wife, because it would be unfair for both women to share the property equally when the other woman obviously came after the property had been acquired, and so definitely has no interest in it.
Thank you very much. Now let's go to Yusuf. Yusuf, you're calling from Cape Coast. What's your question?
The understand is that every marriage has its own peculiar problems. So if this law, I want to know if the law recognizes a situation where on the conveyance you state that if I'm the man, I will state that this property belongs to me alone. And then in registering the land too, I state over there that it is in my name only.
Okay.
Then the second one I want to add is, in the case of where the thing is joint between the man and the woman, I mean the two spouses, in the case of the death of one of them, does the property go, 100% of the property, will it go to the surviving spouse? So these are the two questions I would like to
Thank you, Yusuf. I'll take our next caller and then we'll answer your questions. Okay. Part of your question, my guests have already explained, so they may just repeat that to you. Robert, you're calling us from Adenta. Let's hear you.
Okay, I'm Robert from Adenta. I just joined in the one thing I want to find out. Whether the law takes retrospective effect. That is, let's say I'm married in 2015. Would this law apply to my marriage?
Okay, you are asking whether the law operates retrospectively. So if you married before the law was made. Okay, I think it's about the property.
It's about the property.
So when you acquire the property will be important. But I'm not going to do the answering here. My guests are here to do that.
Okay, then another one is that.
So the rest of you, Mohammed, you are calling from Salaga. Hold on briefly. Okay, so let's begin this time with Mrs. Veronica Frimpong. Yusuf had two questions.
Yeah, hello.
Please unmute. Please unmute. Veronica, please unmute.
Muted.
Yes, we can hear you now.
So Yusuf was asking about peculiarities of marriages, and then he asked what happens if one spouse, he used the man, states that the property is solely acquired by him and registers it, and probably turns out later that the woman is also made some contribution or is a joint owner. I believe that's what he was trying to find out, unless I didn't get it correct.
He was asking if a man can decide, one spouse can decide to go take a property even within the marriage and register it as sole owner of the property without the other party.
Yes, we mentioned that earlier. One spouse can. I mean, once you are able to show that indeed you acquire the property alone and the other spouse doesn't have any.
Let me take these questioners who are online. Mohammed from Salaga. Let's hear from you, and then we'll hear from Enchibwe Siakon, who is also calling from Achimoda. Yes, Mohammed. Did I lose Mohammed? Okay. Mohammed, please forgive us. You can call back and we'll pick your call. Enchibwe Siakon, Achimoda, let's hear you.
Achimoda. This is Enchibwe Siakon from Achimoda. Hello.
Go ahead.
Yes. What I want to say, does this law replace TND? Yeah. What I want to say is that since this law replace TNDC law 111 or complement it.
Okay, thank you. Whether this law replaces the interstate succession law or it complements it. Ibrahim, you are calling us from Wa. Let's hear you. Hello, Ibrahim. Ibrahim, I hear you in the background. Let's hear you. Okay, we seem to have lost Ibrahim. Hello? Yes, go ahead.
Yeah, please, I want to know whether. Yeah, please, I want to know whether we are talking about joint partnership. Yeah, the joint partnership. I want to know whether we are going to consider each proportionate share. So, supposing that maybe the wife's portion is only 2% of the whole ownership, are we going to consider that proportionate share, or the wife's contribution is only 2%, but we are going to regard it as equal share? So I want to know whether the law made
in what circumstance? In what circumstance? Ibrahim, in what circumstance? Upon dissolution of a marriage or upon death?
Yes, I'm talking about when you have a property during the marriage. When you have a property during the marriage.
All right. Thank you for your question. Thank you for your question. Let's begin with Ms. Anto. Yes, you heard Enchibu Esiakon from Oda. His question was simple. And then also Ibrahim from Wa.
Yes, the interstate succession law has not been taken away. This Lands Act complements the interstate succession law, so far as there is no conflict in the provisions of the two laws. And then the issue of proportionate share. As I said earlier, when a property is jointly owned, none of the parties, no matter your contribution, whether it's 1% or 99%, you have equal right to the property.
All right.
Equal right.
Thank you.
By this says that you can make an agreement to separate each person's share and indicate how you want to manage it, even upon dissolution of the partnership.
All right. I think that, Veronica, I'd like you to rather respond to this question, unless you have a further contribution you want to make to the responses that Ms. Anto has given. Eugene Kwesi Jeche is asking, what does contribution mean in this sense? What does contribution mean? He's heard the two of you continuously use the word contribution. What does that mean?
The contribution we are talking about here, you won't find it's not in section 38. We mention contribution because it's the person's contribution to the marriage, and it comes to explain what the joint acquisition is. A joint acquisition, if two, in this case spouses, so let's say two people are acquiring the property, then it means that they would have contributed to the acquisition of the property. This jointly has been explained by the Supreme Court to mean that it's not only financial contribution as previously was held. So before, the contribution should have been made directly towards the property. So if we are buying a house and the man brings, let's say, 5 million, the woman brings 3 million, it is monetary contribution or something that could be calculated in monetary terms. And so if the woman contributed in some other way by even supervising the work, cooking for the workers or doing whatever it is to ensure that the property was acquired, it didn't matter. But at a point, the court came to say that if the contribution is towards the marriage, such that the other party is able to acquire the property, as Mr. Anto initially tried to explain, then it is equally contribution. So it could be contribution in kind, it could be contribution in cash, it could even be contribution by just staying at home, taking care of the children, taking care of the man, and performing your role as a spouse for the other party to have the peace of mind to get the money to acquire the property. So that's what we meant by that. Right.
And in fact, initially, the court's view was that the contribution even has to be substantial.
Yes.
Right. But now we know the Apex Court, the Supreme Court, has been very emphatic. And in the Mensah versus Mensah case, that, like you just explained, it could simply be the chores that a woman has to perform and must not be a contribution directly to the erection of a particular property. Yes, Into, you wanted to say something?
Yes. You mentioned the Mensa and Mensa space. If you permit me, I will just read just one paragraph at the, I think the last page. Yes, the last page. Just above the conclusion, the Supreme Court said something which is very, very relevant to this discussion. You see, the court said, this court is of the considered view that the petitioner's contribution, even as a housewife, in maintaining the house and creating a congenial atmosphere for the respondent to create the economic empire he has built, are enough to earn for her an equal share in the marital properties on offer for distribution upon the decree of divorce. These two parties, they started as farmers. Mensa and Mensa, they started as farmers before they were able to raise capital to set up the business, out of which they acquired so much. But at the end of the day, the woman was being relegated to the background. So the contribution aspect is answered by the Supreme Court.
Right. Okay. Please hold on for us. We take a quick break. We'll be right back. You're welcome back. This is The Law. It's your legal light and health law. And this afternoon, we are thankful to Alexander Etua Into, who is Senior Legal Officer, Lands Commission, Koforidua, and Mrs. Veronica Frimpong, former Legal Officer, Lands Commission, here in Accra, and Head of Legal, SIC, Life Savings and Loans. Now, Stephen is sending a message from Kumasi, and I must inform the two of you, Alex and Vero, that we are getting a lot of messages from particularly men who are angry at the suggestion that there could be an equal share simply by contribution, not in terms of money, into erecting a property or acquiring a property. They are so unhappy. They don't understand what you mean by your explanation of the contribution, which takes away, in certain situations, financial contribution. Hello, Stephen from Kumasi. Let's hear you. Stephen, forgive us. You can call back. Stephen, you can call back. Mohammed from Salaga, you can also call back. And then Jima, you are calling from Siani. Hello, Jima, let's hear you. Yes, Jima, let's hear you.
Yeah, my question is, in a case where it is, let's say that just a housewife, it is easy to date with because you know the contributions they make in the family. But where we have a career woman who is doing her business separate from the man's own, and the man, or let's say either of them work separately to build their own empire or to build their own house, to buy it. How do we deal with this in case there is a divorce? So that we know this is a career person, she has already built her own, and the man too is building towards his own life.
All right.
There is a divorce. How do you solve it?
Thank you, Jima, for calling us from Siani. Yes, let's let the woman begin with the answer to that. Yes.
All right.
The things we say about the joint ownership, they are presumptions. And as the court has rightly pointed out, if upon divorce you're able to prove to the court that, look, even though we were married, we lived as though we were separate people in terms of property acquisitions. Because the man acquired some properties probably in his hometown or did his own things. The woman also did her own thing. So she can't come back now and want to claim part of the properties that the man has. Or with this equality thing, the Supreme Court has subsequently held in some cases that, look, they will take it on a case-by-case basis. So that if you're able to prove that, look, this woman is going about her business, she doesn't really care about what happens in the home, she doesn't take care of children, she doesn't do this, and so I don't see any particular contribution she made in the marriage towards the acquisition of the property, the court will make such determination.
All right. Thank you. Montala, you are calling from Sekandi. Let's hear you.
Question is, let's say I have a children, and then I've done all the necessary everything. I'm building a house, and instead of maybe using my name or my wife's name, I use my children's name, and then maybe in case of death or maybe in case of divorce, in this case, are they going to divide the property, or so they are going to allow my children to take care of the property?
Did you agree with your wife that the properties be registered in the names of the children rather than you, the couple?
Yeah, I have. Maybe okay. I haven't done that.
Okay.
This is how I do it.
Thank you. Thank you. We have heard that. Let me take our very last call. Rashid. Rashid, you are calling from Tamale. Let's hear you.
Thank you so much. Good afternoon. The question is the property we're talking about. Is it only, buildings, estate buildings? Or, for example, if I acquire, say, a degree, in my marriage, I acquire a degree, I apply to a job with a degree, and I get an appointment, and I earn salary from the work that I applied with a degree. That particular salary, will it be mandatory for me to share it with my spouse? Or can we give a definition to the property? Thank you.
Okay, thank you. I don't know how that comes into play, but Veronica, let's begin with Mutala's situation. He's done property and he's doing it in the name of
As far as this law is concerned, we are talking about landed or immovable property. So your salary doesn't come in here. That will be another issue. Probably the spousal rights bill will deal with that.
That's Rashid.
Or the court will deal with it as and when.
This response is to Rashid. But Mutala is saying in the marriage, he's acquiring property, but in the name of the children.
Mutala, if you are acquiring property in the name of the children, children below 18 years cannot hold property. And so parents may hold the property as trustees for the children. If the trustee dies, it doesn't mean that the ultimate beneficial owner loses. They holding it for their children because they are not of age. So if both parents are holding it in trust for their children and one dies, the remaining spouse now holds the property as a trustee for the children because the benefit is for the children.
Right. Yes. Alex.
Something. See, trust is one of the various means couple or spouses can acquire properties to avoid these complications of joint ownership. Trust is one of them. So it has to be done, if it is done genuinely, that you are holding it in trust for the children. The children are the ultimate beneficial owners, as the Bible said. You see, but others may want to hold it in trust for their brothers and sisters, hold it in trust for somebody, or put it in the name of those external family members, as if the property doesn't belong to them. But as it was mentioned, if it comes to land administration, the registrar has the capacity, ability to probe into it, ask more questions. How they did the nature of the trust, he can question the trust and make sure that things are done properly from the onset. Otherwise, it goes to court, then the court will deal with it on case-by-case basis.
Right. And if you are just joining us, remember that our focus is on a new law in Ghana known as the Land Act 2020. And there's a provision of that law as we got Sheila Menka-Premo and Angela Jamnabwaji to explain to us last week. It is a law that sort of enforces a provision of the 1992 Constitution and gives more details as to how spouses can enjoy property rights as to property acquired during the marriage. And the very interesting part of that law, let me read it once again, is titled Restrictions on Transfer of Land by Spouse. Except as otherwise provided, that's section 47, except as otherwise provided in subsections 3 and 4 of section 38, in the absence of a written agreement to the contrary by the spouses in a marriage, a spouse shall not, in respect of land, right or interest in land acquired for valuable consideration during marriage, sell, exchange, transfer, mortgage, lease the land, right or interest in the land, enter into a contract for the sale, exchange, transfer, mortgage, or lease of the land, right or interest in the land, give away the land, right or interest in the land, inter vivos, or enter into any transaction in relation to the land, right or interest in the land, without the written consent of the other spouse, which consent shall not be unreasonably withheld. Simply put, if property is acquired during the marriage, unless a contrary intention has been expressed, it is joint property for both spouses, and one cannot deal with it without the consent of the other. So a man cannot get up to say, I'm going to sell the land. A man cannot get up to say, I'm going to give the land as a gift. They cannot get up to say, I'm going to use it for any other thing except with the written consent of the other spouse in the marriage. Let's take the very final concluding words from our guests, the two lawyers. So start with you, Alexander Etua Into. What would you say to couples in the face of this new law?
The couples should prepare a plan for how they want to acquire properties right from the onset. For those who are already in it, in the marriage already, new couples should prepare from the onset. Those who are in it should start planning from now. They should have to come to terms with the fact that the law requires that you cannot deal with the property anyhow without a written consent. So there must be an agreement, because the law has also made provision for agreement to exclude certain rights.
All right.
So there must be an agreement between the couple. They should sign an agreement that this is how we want to manage this property, which is in the name of one or the other.
Thank you very much. Let's hear Veronica. Yes.
I'm saying 4 things. 1, the registrars at the Lands Commission, land administrators, they have a lot to do in ensuring that this provision or these provisions are actually operationalized to meet the specific goal that it's meant to achieve. 2, sometimes land or property is dealt with in a manner that doesn't necessarily fall under section 46. It's not transferred, it's not sold. But maybe one spouse has so much control over it such that he's the one giving it to family, relations, friends, and stuff like that to live in it. There isn't any particular transaction to it, but he seems to control the property more. It's another area that I believe that federal legislation will help resolve. Then in marriage, because the provision is about marriage, we have to be very careful. And then we need the spousal rights bill, because some of our parents have been together for 30 years. There is no formal ceremony. And, when it comes to death, sometimes the court will, imply some customary marriage of a sort. But during the pendency of the marriage, it becomes a problem. So maybe people
allow us, and my guests have been Alexander Etua-Into and Mrs. Veronica Frimpong, two lawyers who have actually worked together at the Lands Commission. Thank you all so much. I'm Samson Ladia Yanini. This has been The Law. It's your legal light and health law. God willing, we come your way next week with another edition. Thank you so very much. Thank you.